Welcome to EUPrivacyForAll, Session 9 on GDPR, Records of Processing Activities, Article 28. In the negotiations between European Parliament and EU Council about records of processing activities, let's outline a few points. First, the initial drafting by European Parliament was tackling regularly updated documentation obligation. It was switched by EU Council to an obligation to have records of all categories of personal data processing activities under a controller or processor's responsibility. Indeed, in paragraph 2 of Article 28, EU Council added such an obligation for processors. It was also added that records shall be in writing. The key provision in GDPR is Article 28. Each controller shall maintain a record of processing activities under its responsibility. It perfectly suits the Council proposal. The list of items to draft in such records is long. Name and contact details of controller, joint controllers, representative, and data protection officer, if any. Purposes, description of categories of data subjects and of personal data, categories of recipients, transfers of data, envisaged time limits for erasure, and general description of the technical and organizational security measures. It's kind of the same regarding the processor's obligation to maintain records, name and contact details of processors, and of each controller on behalf of which the processor is acting, categories of processing, transfers of data, technical and organizational security measures. An additional provision states that the records shall be in writing, including in an electronic form. Additionally, upon request, the controller and the processor shall make the record available to the supervisory authority. Finally, an exception is quoted. This obligation shall not apply to an enterprise or an organization employing fewer than 250 persons, unless three cases. First, there would be a likely risk that the rights and freedoms of data subject would be impacted. Second, the processing is not occasional. And third, special categories of data would be processed, meaning sensitive data or criminal convictions and offenses. Other interesting provisions in the GDPR are Recital 65, basically stating the same things as Article 28, Article 32 on notification of data breaches, referring to data records, and Article 44 on derogations for specific situations regarding transfer. In directive currently, Article 18.2 specifies that the simplification of or exemption from notification can be established by member states in cases, for instance, in which the controller would have appointed a personal data protection official, that is to say, a DPO. In such a case, he would have an obligation to ensure in an independent manner an internal application of national provisions taken pursuant to this directive and keeping the register of processing operations carried out by the controller only. What should accountable data controllers and processors get prepared for? First, getting ready to document all processing activities under their responsibility. Second, drafting records of processing activities in writing, including in an electronic form. Upon request, make the record available to the supervisory authority and document suitable safeguards with regard to data transfers. A caveat: as previously mentioned, this record obligation shall not apply to enterprise or organizations employing fewer than 250 persons, unless they fall into, first, a case in which there would be a likely risk that rights and freedoms of data subject would be impacted, processing is not occasional, or the processing includes special categories of data. Records templates shall be drafted, and it will be interesting to know what is the granularity and final format retained as acceptable.